So you want to change your judge. Well, in Illinois, that's actually quite difficult. To be fair, I've yet to see the losing party ever walk out of court and say, well, I guess I really was the bad guy. The truth is, the guilty often protest the unfairness of the process with the same or even greater sincerity than the wrongly convicted. And if you allowed every dissatisfied party the option to change judges when things weren't going their way, well, truth be told, cases would probably go on in perpetuity. In Illinois, there's really 3.5 ways you can change your judge, and today's case gives a nice overview of part of that process. First, you can change judges as a matter of right, but you lose that right if you wait too long or the judge already made a substantive ruling, or some other action that gave the parties a heads up on where the court might be going. The second is a substitution for cause. Now, these actually go before a different judge to decide if the assigned judge acted in such a way to demonstrate actual prejudice. One extreme example might be if one of the parties is Jewish, the judge makes an anti-Semitic remark from the bench. It kind of makes it clear the fix might be in. Sadly, however, many people file these requests because they don't like that their argument isn't overcoming the other side's, which really isn't a valid reason to seek a change. Again, you have to show actual prejudice. They're also very awkward to lose because if the neutral judge hearing your motion denies it, you go right back to the judge handling the case. The third is called a motion for reclusal, and as the opinion notes, this request does not go before a different judge, as the issue isn't prejudice, it's actually conflict of interest. Rule 63 lists a variety of ways a judge might have to step away from a case. Most of the time, the judge actually does this sua sponte, that means on their own. Sometimes, like in today's opinion, the judge who was a former prosecutor handled a case involving the defendant eons ago and is now overseeing a different case involving the same defendant as a judge. So defense counsel in that situation might file a motion to argue it from there. The final way actually isn't. It's kind of county specific. For example, in Cook County, we have local rule 13.6 because oftentimes judges will switch divisions with no warning. So Judge A, who's been handling the case for X number of years, suddenly goes to the law division, and now you have Judge B. Well, let's say your client really likes the new judge a lot more than the old one. What's the worst thing you can do if your Cook County family law case is in that situation? Well, under Rule 13.6, it might be to file a motion to vacate anything because if it falls under 1203, it must go back before the Judge A, and if under 1401, it probably will go back to Judge A. Judge B actually gets to decide that. Family law is a chess game, and substitution is a small part of that. Knowing when you should and shouldn't can be crucial to your case. Litigate accordingly.